May please the court. Our submission for notice to answer will be taken by Dr. Matthew Whitrock. Our submissions for no case to answer will be taken by Dr. Matthew Whitrock.
May it please the court. The submission of the amicus curiae team regarding the prosecution of this case is that there is no case to answer. Firstly, in regards to charge 3, the prosecution has failed to prove its case. While there's no doubt that wrongs have been committed, the elements of crime alleged in the present case have not been proven. In particular, in relation to the allegation of genocide, the dolus specialis requirement for the crime has not been met, while the mens rea for the intent to commit the action has arguably been met. The specific intent required for the element to substantiate a charge of genocide has not been attained by prosecution in the present case. The burden of proof for the charge of genocide is much higher than your typical criminal offense. As a result, the threshold must be proven beyond a reasonable doubt, almost to a certainty, in order to maintain that the criminal act did in fact constitute genocide. Secondly, in regards to charge 4, the tribunal lacks jurisdiction over the present case at bar, while the ruling submitted by the tribunal in regards to jurisdiction earlier considered the issue of universal jurisdiction. It failed to account for the consent to jurisdiction required to adjudicate a proceeding involving a dispute to which one state is a party. All right. Universal jurisdiction refers to the ability, if not obligation, of a body to exercise jurisdiction over an offense that is universally condemned. All right. However, the ability of a judicial body to exercise jurisdiction over an individual, a natural legal person, differs from the exercise of jurisdiction over a state. States, as parties to a dispute, must consent to the jurisdiction of the judicial body for jurisdiction. All right. The 2 cases referred to in the ruling concerning the jurisdiction of the tribunal, Congo versus Rwanda, and the genocide case. All right. In both instances, the International Court of Justice rendered rulings. All right. In regards to the genocide case, the International Court of Justice ruled that it did maintain jurisdiction on the basis of the fact that genocide was a jus cogens, and on the basis that it was accorded jurisdiction in accordance with Article 9 of the Genocide Convention. However, in the similar case, the case of the Democratic Republic of Rwanda, the Congo versus Rwanda, all right, the International Court of Justice held that due to the existence of a reservation against Article 9, which confers jurisdiction over disputes arising between 2 state parties to the convention, the International Court of Justice was unable to exercise jurisdiction on the basis of want of jurisdiction. The State of Israel has not agreed to participate in the present proceedings, nor has it accepted the jurisdiction of the tribunal in the present proceedings. Therefore, the tribunal cannot legally assert that it may exercise jurisdiction over the alleged conduct of the State of Israel.
Basically, you're saying that the Rwanda case overrides the previous one.
No, sorry. What I'm saying is the identical principles were applied in both the Rwanda decision and the genocide case decision. They both stem from the initial jurisprudence from the International Court of Justice on the subject of consent to jurisdiction as early as East Timor. That's a pivotal case in the jurisprudence of the International Court of Justice. However, in regards to consent to jurisdiction, once again, in the Rwanda case, because the International Court of Justice did not have express or explicit consent by the state party to the dispute, they were unable to exercise jurisdiction over the dispute. This, Your Honors, is also an accepted principle of customary international law, as referred to in the decision in Rwanda and in the separate opinions of Judge
The state commits grave atrocities, crimes against humanity, genocide, but does not consent. International law is helpless.
In the present dispute involving the state of Israel, arguably the tribunal lacks, well, as a matter of fact, in accordance with international law, the tribunal lacks jurisdiction over the state. International law is not helpless in regards to universal jurisdiction and the lack of sovereign immunities or acts of jus cogens. Universal jurisdiction can be applied in the case of individual criminals for the purposes of liability.
The state commits the most heinous of offenses. I'm not talking of Israel, any state, but says, keep away, don't interfere. I'm a sovereign state. Sovereignty is a shield against everything. So your view is that nothing can be done.
In regards to the criminal liability, the matter brought before the tribunal today is a matter of criminal liability in particular. In regards to the state, there's nothing to suggest or support an argument that a state can maintain liability for a criminal offense under contemporary international law. The state may be held responsible under state responsibility. However, in those instances, it's limited to reparations, all right, consisting of based upon tort and restitution, all right. The distinction, all right, and again, I understand that there are many arguments and issues concerning the lack of criminal jurisdiction over states. However, you must understand criminal responsibility and criminal liability in relation to international human rights norms and international humanitarian legal norms, which prohibit collective responsibility and collective punishment. If you are to assign or ascribe criminal liability to the state, you are effectively charging, all right, you are indicting every individual in the territory of Israel. Okay? The entire purpose of individual criminal responsibility under international law is to ensure that the individuals responsible for the commission of a criminal act are held liable and held accountable, all right, while at the same time guaranteeing due process to those individuals due process to individuals that did not actively participate and are not liable for the actions that occurred. If you, in the present case, for example, if you are to suggest that there is criminal liability to the state of Israel, Palestinians that happen to reside in Israel, all right, by circumstance alone, are found guilty, all right, and are condemned alongside the people that actually committed the crimes, the individuals that actually have liability for the criminal actions. That, under international human rights law and international humanitarian law, is unjustifiable.
Is it possible to limit the liability to the leaders of the state who make the decision rather than to the ordinary farmer trying to eke out an existence? In commercial law, for example, when companies commit crimes, you don't go to every shareholder, you go to the brain and nerve center, and you say they are the ones who are liable. So this idea that the entire population of the state must be held liable if the state is found guilty, I think to convince me a little bit more on that.
Yes, sure. The distinction to use, to apply a domestic analogy the distinction between state responsibility and criminal responsibility under international law effectively mirrors that of civil liability and criminal liability. Okay? In regards to criminal liability, if you want to assert that specific individuals are criminally liable for offenses committed, all right, that is well within accepted international legal practice and the practice of national legal systems. However, in regards to state responsibility, as mentioned previously, it's civil in nature. You can assess a state for reparations based upon restitution and torts. However, punitive damages to date are not allowed, as they themselves actually constitute a form of collective punishment upon the populace of the state. Initially, in international legal practice, prior to the 20th century, punitive damages were allowed. Collective responsibility was allowed. Following the practice of Nuremberg, with the Nuremberg military tribunals, there were only 2 or 3 instances where collective liability was established, and that was only established in cases where you could not determine which specific individuals participated in the commission of an offense. These issues are not presented before the court today. There's sufficient evidence to warrant individual indictments over which the court may exercise jurisdiction on the basis of universal jurisdiction. However, the tribunal's exercise of jurisdiction over the state of Israel and its conduct on the basis of state responsibility rather than criminal responsibility is limited.
National law evolving, or is it still the way it was at the time of Nuremberg, Tokyo? I know at one time state sovereignty was a shield against external aggression, but you are going so far as to say it's also a sword available to a state to commit murder against its own citizens or citizens of others and get away with it. So is that how far state sovereignty goes, really? I thought things are changing in international law.
Again, in regards to Your Honor's question, the state in and of itself is not a natural legal person. It's a corporate entity. All right, it's a legal fiction. It's an artificial person for the purposes of international law. Therefore, you can't actually. There's no basis to assert a claim that a state, all right, that as an abstract legal entity is actually capable of committing a crime. It is the individual agents, the individual actors, and the individual organs of that state that are responsible for the commissions of the offenses, not the state in and of itself. Bearing in mind that the international legal definition of a state includes the government, the population, the territory. All right. If you charge a state collectively for a criminal offense, you are asserting that the liability extends to all of the components of that state, with the exception of territory, obviously. However, in light of the fact that international law is presently evolving, you can't argue that at some point in the future we might cross the threshold, but that threshold has not been reached now. And these very same arguments were raised in the separate opinions in the Rwanda case. All right, Judge Al-Arabi again explicitly refers to the fact that she is not happy with the fact that in regards to state disputes, that states may say, we don't want to consent to jurisdiction, therefore your rules don't apply. She's not happy with the fact, but at the same time she also recognizes the fact that it is a customary international law, and until that changes, all right, until there's reason to suggest that law has been replaced, that is the law which governs. But once again, the issue at stake here is not sovereign immunities. Traditionally, sovereign immunities in the context of humanitarian legal offenses and human rights offenses have been used to shield individuals from prosecution. The issue at stake here is whether or not it is legal. It would be legal in any regards to assess collective responsibility or collective liability to a state on the basis that it violates another customary international law, which is that you cannot legally rule that collective punishment is the outcome of a trial, which would indeed be the case if the judge or if this court maintained jurisdiction over the state of Israel for criminal liability. But as I said, state responsibility is an avenue which can be pursued.
Dr. Matthews, I have 3 questions here which I would like to address the tribunal. First, can you explain to me the doctrine of just cogence? And second, whether the principle of state sovereign immunity has reached the status of jus cogens. 3, if there is a conflict between jus cogens and sovereign immunity, which will prevail?
Your Honor, the concept of jus cogens is fundamentally predicated. It's based on the fact that certain actions, certain conduct is universally condemned within the international community. As such, any action which constitutes a jus cogens violation, can be enforced, punished, or prevented by other states and other jurisdictions. And other states and other jurisdictions. Effectively, states within the international community, judicial bodies within the international community, not only have a right to prosecute on jus cogens on the basis of universal jurisdiction, they have an obligation to do so as an erga omnes. Right? Erga omnes refers to the obligation. Jus cogens refers to the actual offense, the conduct in question. Okay. In regards to sovereign immunity, sovereign immunities have existed throughout the history of international law. The power of sovereign immunity is waning. Arguably, I would argue that the consent to jurisdiction is not in and of itself a sovereign immunity. It is a right accorded to states under international law. It is a customary international legal norm in and of itself. All right. Now, I am aware of the fact that custom, international legal custom, can come into existence and it can cease to exist. At the moment, the pivotal question is whether or not the basis for jurisdiction, being consent, is still is at the moment recognized under international law. There is no proof to the contrary. There is no proof to the contrary. Therefore, it must be assumed to continue to exist. In relation to the conflict, if there's a conflict between jus cogens, and sovereign immunity, to date, foreign sovereign immunities such as head of state immunity, diplomatic immunity, these have been waived. These are universally recognized as no longer being applicable in cases involving actions or conduct that are jus cogens in nature. However, that is based upon individual liability, individual responsibility. As a matter of law, the consent to jurisdiction still exists and must be adhered to by the tribunal.
You made the analogy that the state is like a corporate person. But corporate criminal liability is quite broadly recognized. It's debatable. It's debated. But I wonder why you can say that the analogy of corporate liability prevents a state from being punished under criminal law. when a corporation can be in many jurisdictions.
The use of the term corporate entity, it's referring to the nature of the state itself. It is a corporate entity. It has a head representing the body, which is the population of the state. It was not my intention to say that a state is similar to a corporation. The two are distinct subjects and or objects in international law, and they are distinct subjects and or objects in national law. Distinct subjects or objects in national law. The criminalization of conduct of corporations within national legal systems is not disputed. It's that several states have, in fact, enacted legislation to allow their judicial bodies to exercise jurisdiction over criminal liability of corporations. Furthermore, it is not contested that other corporate entities under international law may be assessed criminal liability. However, they are non-state entities in each case. Armed groups, for example, are corporate entities under international law. They may be held to be criminally liable in proceedings. This is relatively accepted. However, states at present still maintain, that the state practice and the practice of international tribunals and other international judicial bodies at present still recognize and still maintain that consent-based jurisdiction or a consensual-based upon a consensual nature of the international judicial proceedings in and of themselves continues to exist to this day, as was held by the International Court of Justice in 2007.
Are you saying that in every case, where there is in every case of a sovereign state, you can claim immunity, notwithstanding whether that is the organ of the government? You appreciate what I say, is that you cannot impede a sovereign state almost every case. That's it.
Your Honor, I am not attempting to assert that at all. There are a variety of mechanisms and means by which a state can be held accountable for actions under international law. For example, as referred to earlier, the Genocide Convention, Article 9, it specifically and explicitly provides that any disputes arising between two state parties to the convention are to be can be heard by the International Court of Justice. The International Court of Justice has used this as a basis to exercise jurisdiction in cases where the states have argued against the basis for the jurisdiction of the ICJ purely based upon consent. ICCP, the International Convention on the Elimination of Racial Discrimination, also contains similar compromissory clauses, which allow for jurisdiction by specific tribunals or specific international judicial bodies in the event that a dispute arises. However, in the present instance, in the present case, this tribunal is not explicitly mentioned in the provisions of the Genocide Convention. And in accordance with the Vienna Convention on the Law of Treaties, Articles 31 to 33, it cannot be construed, the Genocide Convention in and of itself cannot be construed to allow this tribunal to exercise jurisdiction without consent by the state party.
Article 6, Chapter 3, Article 6, Clause B. Page 34.
Arguably, Your Honors, I would argue that under this provision, that this tribunal, for the purposes of an advisory opinion, can exercise jurisdiction. Similar accommodations, similar arrangements have taken place in the practice of the International Court of Justice. Advisory opinions have been issued and have been answered by the International Court of Justice without requiring consent. The charter of the Kuala Lumpur Foundation to Criminalize War makes similar provisions. I would argue that this, in regards to international legality, is the most legitimate basis by which this tribunal can exercise jurisdiction over the charges presented before it today. In relation to the state of Israel.
Yeah, if you look at the International Court of Justice list of contentious cases, you will realize that most of the cases are brought by and against states. So how do you argue that actions cannot be brought against states?
Again, Your Honor, in relation to your query, the fact that there are numerous contentious cases before the International Court of Justice at present does not invalidate my former assessment of the situation. States bringing forward claims to the International Court of Justice consent to the proceedings by participating in the proceedings. Participation is a passive form of consent. Okay? In the present circumstance, the state of Israel has not consented to jurisdiction. They have not answered the charge, despite the fact that the charge was serviced to the Prime Minister's office. In the present instance, the argument cannot be made that the state of Israel has explicitly, expressively, or tacitly accepted the jurisdiction of this tribunal.
Yes, but as far as genocide is concerned, it has been regarded as jus cogens, as what has been stated earlier. So when it has reached that level, there's no need for states to agree or not to agree to be brought to the court. And as far as your argument about erga omnes, about states' responsibility, state has the responsibility to protect other states. And how do you argue this doctrine of erga omnes?
I'm sorry, Your Honor. Could you clarify the first question, please?
The first question is in regards of jus cogens. You've mentioned just now that states need to be agreeable to be brought to the court. But as far as genocide and other war crime is concerned, it has been acceptable by the international community that it is a customary international law, it is jus cogens, whereby states do not have to accept whether to be brought to the court or otherwise. In other words, even if the state do not agree to be brought to the court, the state can be brought to the court. It has been acceptable. So how do you argue on that point?
In other words, customary international law overrides the requirement of consent. And that's what my learning means.
In regards to Your Honor's first question, if I'm understanding the question correctly, I can think of no instance in which a state has been brought before a court concerning conduct amounting to genocide without its consent. Again, in the Democratic Republic of Congo versus Rwanda, both states consented to the proceedings. Again, in the genocide case before the International Court of Justice, both states consented to the proceedings. If you look at the conduct of the International Criminal Tribunal for former Yugoslavia, the International Criminal Tribunal for Rwanda, the International Military Tribunals at Nuremberg, the Tokyo War Trials, none of these judicial bodies attempted to exert jurisdiction over states. These states were not, in fact, parties to the dispute. In each instance, it is the individuals acting as agents, organs, or officers of the states. These tribunals have been established to assess the individual criminal liability of specific individuals, key individuals and ministers involved in the commission of acts of genocide, war crimes, crimes against humanity, crimes against peace. But in no instance has there been a trial of a state before a legitimate and legal international tribunal or court that involves a state being put on trial, without consent, and a judgment being rendered, with the exception of arguably advisory opinions under the ICJ.
In that case, then we should set a precedent.
If the precedent can be reasonably established and is consistent with contemporary and recognized international legal norms and is well reasoned, the tribunal is free to do so. However, at the present moment, there is no argument in regards to the non-existence of jurisdiction based upon the consent, explicit, express, or tacit consent of a state to judicial proceedings. None. That is all. I will end my submission.